morning, Your Honors.
Good morning, Counsel.
May it please the Court. My name is Manny Mesa, and I'm here on behalf of the appellant Excellent Computing Distributors in this case, and I'd like to respectfully reserve 2 minutes for rebuttal.
Sure.
Your Honors, we are here to decide basically one issue of law, and that is whether the trial court correctly entered summary final judgment in favor of Miami Airport Condominium and against Excellent Computing. We respectfully submit that they did not for 4 reasons. I'd like to just mention some of the salient facts if the Court would permit me to do that. I believe that the relevant facts are this involves a commercial warehouse facility. It's rectangular buildings, several of them within a unit, and all of the common areas are under the exclusive control of Miami Airport Condominium. The appellant in this case owns 2 commercial units within one of those buildings. And the case began when there was a burglary which occurred in April of 2008. In that burglary, unknown people blowtorched the door, removed the door, entered the premises, deactivated the alarm, proceeded to use the forklifts that were inside the place to move around pallets of merchandise, eventually located the most valuable merchandise, and then proceeded to load those by opening the bay door at the back, loading it onto a truck.
Okay.
Now,
we have the basic facts.
okay. And
So there was a burglary on one of the units. One of the units was a victim of a burglary.
yes, the unit owned by Excellent was the victim of the
Right.
burglary. As a result of that, Your Honors, we filed suit against Crime Stoppers, which were the company that was providing actual security monitoring with golf carts. And
That's still alive, though, right?
yes, sir.
Yeah.
Yes, sir.
Your biggest problem, and I think we all understand it, is the language in the master covenant and the condominium documents, and
Yes,
the
sir.
release of the association, essentially, or promise to not file a lawsuit against the association for any of these issues, and so on. That's your biggest problem here, is it not?
That's correct. Yes, Your Honor.
So how do you deal with that mountain that you need to climb? I don't want to suggest to you that it's going to be difficult, but it is a mountain when your client signs the association documents, and I'm aware that the client said that he didn't read the documents, but that's of no moment.
Yeah.
So
Your Honor,
as Judge Logue asked the prior attorney, give me your best argument
my
about
best
why
argument.
we should not enforce that master covenant.
I'll try to cross the mountain, Your Honor. We have 4 reasons that we believe that the decision should be reversed. I think the first and foremost is that the exculpatory clause conflicts with several other clauses within the Declaration of Condominium. First clause that it conflicts with is Section 2.14, where and I'm paraphrasing, the Declaration of Condominium says we're going to charge you, the property owner, for common expenses, and those common expenses include protection of the common elements. You go to another section, which is Article 4, entitled Powers and Duties of the Association. This is found in the record, Volume 3. I believe it begins in page 309. And subsection F indicates that the duty of the association is to install and maintain security devices, detectors, and communication facilities, and employ or contract for employment of security services, guards, and watchmen for the common areas. We respectfully submit that these provisions, which set forth an affirmative duty to protect the common areas, which are under the exclusive control of the condominium and which cannot be monitored by us without agreement of the condominium, create a conflict. And those conflicts are generally construed against the drafter, which in this case was obviously the condominium association. Now, there's one of the cases that supports this theory, and this argument is one of the cases that was incidentally cited by the appellee, which is Shields versus Andros Isle. That case, which is a 4th District Court case, which was cited by them for a different proposition, that indicates that if there is a doubt as to the meaning of any of the words in the condominium declaration, the doubt must be resolved against the party seeking the enforcement. We respectfully submit that because those provisions exist, it does create a conflict, and they should be interpreted and construed against Miami Airport's position.
So here's the language, and you're saying this is ambiguous. Quote, developer shall not in any way or manner be held liable or responsible for any violation of this declaration. All owners agree to hold developer and the association harmless from any loss or claim arising from the occurrence of any crime or other act. I mean, that seems pretty clear.
Your Honor, I think that respectfully, for people like us, which are trained in the law and which look at these kinds of agreements, we probably have a fair idea of what it means. But in this court, in the case of Tout versus Hartford, and also in the 1st District Court of Appeal, 4th District Court of Appeal, 2nd District Court of Appeal, cases of Levine versus Madley, Van Twine versus Zurich, Goings versus Jack, the only 5th District is the only one that hasn't ruled that way. When you're dealing with exculpatory clauses, they have to be specific. In this case, we don't have the words negligent in any of the clauses that have been cited in bold and in many pages of the appellee's brief. And therefore, even though perhaps one of us may understand what it means, or we may think we do, we have to abide by the plain language of the provision.
And as a matter of fact, the complaint is a complaint for negligence. Am I correct? Negligence in failing to have the proper security.
That is correct, Your Honor. That is correct. We believe that the conflict is, number one, the provision is not specific enough, and number two, there's a conflict between the exculpatory clause itself and those other provisions that we have cited.
Let me read further. The developer nor any successor developer shall be liable for any loss or damage by reason or failure to provide adequate security or ineffectiveness of security measures taken, if any. I mean, is that subject to 2 readings?
It may be, and that's the problem, because it may
You
be.
say maybe. What's the reading? I mean, not liable for any loss or damage.
If you look
by
at
reason
the
of failure to provide adequate security or ineffectiveness of security measures undertaken, if any. You're alleging that your client's alleging there was ineffectiveness of security measures. That they undertook security measures and that they were ineffective.
We believe that they were ineffective, yes, Your Honor, and
that seems to be, almost within the
Well, I think that the only way that the court can reconcile the language of all these provisions together is to conclude that it's referring to damages or to an allegation of negligence within private property. That's the only way that it can be reconciled without finding that it's a violation.
Tell me that again. I mean, you're saying between the common areas and the unit
right.
areas?
Because if you think about it, if they have exclusive control of the common areas, and we can't control the common areas, then we would never have a remedy for something like this, because they have to go through the common areas to get in. They have to go through the common areas to take the merchandise out and complete the damage that was caused.
But that suggests that you would never have any responsibility.
That suggests that we would never have a remedy, because we would not be able to hire.
But it suggests that you also wouldn't need to do anything at all to protect your client, not you. Your client would never have to do anything at all to protect himself, because the security requirements of the association are so stringent that no one could ever get to the client's property, so it's absolutely safe.
That was what the client believed, that they were safe, and that's why they bought this property. In addition to that, they had security inside their place. They had a closed circuit
security, correct?
And that was.
So if the client had their own security, then how could they have believed that was even necessary if they were going to be absolutely protected by the association?
Because the association had the absolute charge to protect the common elements.
No. If
the
the client truly believed that they were absolutely safe because the association was going to put Superman out there and protect the common elements so that no one could ever get in there,
right,
then why would they have their own security?
Well, Your Honor, there's other issues too, and that is in places like this where you have a high-volume business and you have a lot of people coming in and out, sometimes you want to have closed-circuit TVs to make sure people don't steal from within.
Right.
So, there's other reasons for it too.
Okay.
So, incidentally, that whole system was also stolen by the burglars. And the incredible thing is that it was never detected. The security people never found out about it. They were in there for hours, and it was 24 hours later when the pregnant employee went to go put a crib inside of the warehouse to store it that she discovered the door had been burned off. So she discovered it. So they never discovered it, and it was 24 hours. And that's
You sound like amazing burglars that are going in.
I was impressed by it, honestly.
Tractor
It is
trailers to load stuff. But in all seriousness, I mean, this is a commercial condo, and these documents seem to be written, the way I would interpret them is, look, this is a commercial agreement. We're not buying insurance for you. You got to buy your own insurance.
Well, here's the interesting part.
We're going to decide up front who's buying insurance for what. So the condo association has no liability whatsoever for any of this stuff. And I think between commercial people that's code for, hey, I ain't buying the insurance, you better buy the insurance.
Well, it's interesting that you bring that point up, because in Article 9, Section 4 of the Condominium Declaration, the association has to procure insurance for these kinds of claims. So in other words, there's an affirmative duty for them to have insurance for those claims. So if their intention was we can never be sued, why would you have to have insurance for this type of claim which you can't bring?
Well, because even though the language is very clear, people might sue them.
I think invariably someone will sue, as you well did. I mean,
Yes, we did.
And I'm not suggesting that what you did isn't something that you should have done.
Right.
But we have a different issue to deal with.
Well, Your Honors, even if the court believes that these provisions are can be reconciled and there's no conflict and that it is enforceable, there's another issue. And I think given the facts in this case, given all of the things that we've talked about, there's ample evidence to support that the inference and the direct evidence that there was gross negligence on the part of all of these defendants. And under the case of Southworth McGill versus Southern Bell, which we cite, it's a first district case that recognizes a third district case of electronic security versus Southern Bell. Willful, malicious, gross negligence, though that type of conduct is an express exclusion to this type of exculpatory clause. So I think that because we're at a summary judgment stage where all the inferences have to be drawn in favor of the non-moving party, which is the appellant in this case, a reasonable jury could find that all of these facts, failure to even know that this happened for over 24 hours, is gross negligence. And we respectfully submit that even on that basis, it should be reversed. Now, we also have another position, and that is that once they undertook the duty, there's also a line of cases that once the association undertakes a duty to provide this care, then they have to do it reasonably. And that is under the case of Vasquez versus Lago Grande, Felson versus FPL, and there's a Supreme Court case, Union Park versus Kathleen. And those, to quote the third district case, the judge indicated, once Lago Grande advertised security and collected a fee for providing it, it was required to do so with reasonable care. It didn't happen in that case. And here, respectfully, it didn't happen either. We've been paying for security. We've relied on it. We've seen the people go around, and it was absolutely, they completely, utterly failed to do their jobs. So we respectfully request, Your Honors, that the court reverse the trial court ruling, remand the case for further proceedings so that we can proceed to a trial on the merits.
Thank you very
Thank
much,
you.
Counsel. Counsel?
Good morning. Hinda Klein here on behalf of the appellee. This is not a case about whether or not there was a duty or a breach of duty. This is a case about whether clear and unambiguous condominium documents should be enforced as they are written. These documents could not be more clear and unambiguous, and in fact, there really has been no argument raised as to the clarity other than the implication that somehow because the appellants were not lawyers, they shouldn't be read to have understood them.
That doesn't carry much water.
And they were commercial business people. They certainly knew where the lawyers were and could hire him, and probably did, for the purpose of closing on the condominium.
Right.
So I don't know whether they did or not, but either way.
Correct, and they admitted that they had gotten the condominium documents at that time. This was a $1.5 million condominium, and the goods that were stolen were in the neighborhood, according to them, of $1 million. And as the court has recognized, they did in fact have their own security with ADT, who they had sued in this case as well, and who got out on the same kind of exculpatory language as is present in these declarations of condominiums.
Well, but we're dealing with two different types of entities. One is a security company, and another one is the condo association.
That's correct.
Let me ask you a couple of questions that counsel went by very quickly, but bothers me. The lawsuit here was a lawsuit for negligence. Whether I agree with it or not, it was a lawsuit for negligence. And I don't see the word negligence anywhere in these condo documents to be in the exculpatory clauses. And the third DCA that we're in, our district requires the word negligence to be in the exculpatory clause for you to be able to exclude your own liability for negligence. So we're here on a summary judgment. Our standard review is what, de novo?
De novo, yes.
So, I mean, how do you get past that?
Because it's not just an exculpatory clause, it's a hold harmless clause, and it's a very specific hold harmless clause, which essentially says the owner agrees to bear the risks of any loss or damage here. It's not simply a matter of you agree to hold us harmless if we are negligent or grossly negligent or anything else. It's simply that these commercial parties have each agreed to bear certain risks.
It says that no matter what happens, I'll bear my own risk.
Exactly, and as a matter of fact,
what
the court did ask about the issue of insurance, and on page 355 of the record on appeal, there is a specific section of the declaration governing insurance, and it says, unit owners may obtain insurance coverage at their own expense and at their own discretion upon the property lying within the boundaries of their unit, including but not limited to their personal property and for their personal liability and living expense and for other risks. These documents could not be more clear and unambiguous, and they're not simply exculpatory clauses. They go further.
So your argument to help to get past my situation is that you would draw a distinction between a run-of-the-mill exculpatory clause, and this is a very specific hold harmless agreement.
Correct.
Which is very thorough and very detailed.
As Judge Logue noted, it expressly renders us not liable for inadequate security, as a matter of fact.
And it specifically addresses the type of loss that occurred here.
Exactly. And with respect to the argument that there might be gross negligence in this case, I would just simply point out that the complaint at issue here was a simple negligence. There was no argument as to gross negligence. Honestly, I don't have anything further. I would rest on my brief, and I would ask the court to affirm the summary judgment in our favor.
Thank you very much, counsel. Counsel, a couple minutes for rebuttal.
Thank you, Your Honor. I just have two brief points. One, in notice of supplemental authority filed by the appellee, the case is called Give Kids the World versus Stacy Sanislow. This is the 5th District case where they have a different opinion than the rest of the districts on the issue of how specific the exculpatory clause has to be. And in the 5th District, it doesn't have to have the word negligence. But there was a concurring special opinion by Judge Cohen who mentions that he disagrees with that, even though he believes that he has to follow the 5th District decisions. And what he says is interesting, and I'll quote, "While those trained in the law might understand and appreciate that the general language releasing a party from any and all liability could encompass the injuries suffered by Ms. Sanislow, a release should be readily understandable so that an ordinary and knowledgeable person would know what is being contracted away. I would suggest that the average ordinary and knowledgeable person would not understand from such language that they were absolving an entity from a duty to use reasonable care." They actually go on and say that it should essentially say negligence. So that's some support for the argument that I made before. And the second issue, Your Honor, is that because opposing counsel mentioned the gross negligence, that is an issue for a jury to decide. And the level of proof, I think that we've got the inferences that can be drawn from what's undisputed, is that it probably went way and above beyond a simple,
Did you allege gross negligence?
Dropped the ball. I don't recall, Your Honor, if we did.
did not allege gross negligence.
Yeah.
Simple negligence was what was alleged. But you're saying it still required an evidentiary hearing.
Exactly, Your Honor.
Leave it up to the jury to decide.
To the trier of facts.
Exactly, Your Honor.
Got it.
Okay,
Thank you very much, Your Honor.
Thank you both very much. We're going to